Hey everybody, how are you doing? John here with a brief lecture on the topic of confidentiality and privileged communication. So if you think back a couple weeks to the beginning of the semester, when I asked everyone to identify ethical issues that are a significant concern for them, remember that confidentiality was by far and away the most frequently identified ethical area of concern by the class. This is actually not an uncommon occurrence for 664 or among professional counselors more broadly. So take a look at the slide with our data on there. We've got 50% of the class identified confidentiality as the number one concern. And then if we look at this data from a section of 664 that I taught over the summer, now these students are on-campus generalist counseling program students, but you can see that they also identified confidentiality as their leading concern, although not by quite as big a margin as our section did. I've actually tracked this data for, I think, 4 sections, and without fail, confidentiality is always the number one concern. So just what is confidentiality in terms of ethical standards and ethical practice? Well, on paper, the idea of confidentiality is fairly simple, right? It's just a promise or contract to respect the privacy of clients by not disclosing anything revealed to counselors except for under agreed upon conditions. So if the idea of confidentiality is so simple, then how come it's frequently an area of concern that students really want to make sure they're clear on? Well, to some extent, the same concern is evident among practicing professional counselors. Researchers Shaw and Lane published a study in 2008, partly in preparation for the development of the current 2010 Code of Professional Ethics for Rehabilitation Counselors. If you think back to when we talked about quantification as a tool for making ethical decisions, the Shaw and Lane study is an example of using quantification to make ethical decisions at the professional organization level. What they did was investigate the advisory opinion archive of the Commission on Rehabilitation Counselor Certification. Issues related to professional roles and relationships receive the most inquiries, and we'll talk about that topic in depth in a couple of weeks. Issues related to confidentiality received the second largest number of inquiries. So we can see that professionals across their whole career wrestle with ideas about confidentiality. So interestingly, along with the article that Shaw and Lane published, they included a case example extracted from the Advisory Opinion Archive. So this vignette represents an actual case that a counselor submitted to CRCC for an advisory opinion. And as you could see on the slide, the counselor indicated that he recently learned that a workers' compensation client is working part-time and has not notified the carrier of his unemployment insurance. Employment status could impact the client's right to benefits, so this person, the client, is collecting benefits that the counselor's thinking the client might not be entitled to. And the counselor wants to know what he should do. Would it be a violation of confidentiality to report the client to the insurance carrier? they say, what CRCC says, is that if the counselor is legally obligated to report such knowledge to the carrier, he may do so. However, it is incumbent upon the counselor, upon rehabilitation counselors generally, to properly disclose to clients the limits of confidentiality at the onset of the counseling relationship, so that clients are aware of the limits and the potential repercussions of their actions. What I think is interesting here, if we can break down the response a little bit, is subtle things in the wording. If you are legally obligated to report, you may do so. So what they're basically saying in the first part of the answer is, well, you can kind of tell on your client if the law requires you to. It does not say that you must or should report your client. It says you may. And even then, it says that if the law requires you to, you may. So reading between the lines, I hear them saying that they do not really want to see this counselor report on his client. Clearly there's some room for interpretation, but that's how I read the first part of the advisory opinion. The second part of the answer is very important and provides guidance indicating that it is incumbent upon rehabilitation counselors to properly disclose at the onset of the relationship. So here, we're talking about informed consent and professional disclosure and letting people know up front where the limits of confidentiality are, so we don't find ourselves in the position that this counselor found him or herself. The counselor doesn't seem to want to be holding on to this secret information about the client's behavior. But if the counselor hasn't informed the client previously about the boundaries of confidentiality, and the client believes that they have blanket protection provided by confidentiality, well, there's going to be some ethical tension there, right? I point to this example because for me it frames nicely where the field comes down in terms of the importance of confidentiality. As a profession, the field really wants us to maintain confidentiality. Clearly, there are times when we cannot, but the overriding position, the default position, is that we maintain confidentiality. Let's consider a little more specifically just what is provided for by the ethical standards of privacy and confidentiality. Privacy is a very broad idea that protects an individual's right to conceal that they have sought counseling, and then also conceal what is communicated in counseling. So it's more of an underlying idea. And then confidentiality gets a little more specific, and it's aimed at putting parameters around information that is shared in the counseling sessions specifically. So shifting from an ethics framework to a legal framework, privileged communication reflects how confidentiality and privacy are protected legally. It's important to note that privileged communication is the client's right, not the counselor's right, to prevent confidential information from being revealed in legal proceedings. It's the client's right, even though the steps to protect privileged communication are incumbent upon the counselor. Again, as counselors, the default position we maintain is confidentiality. That's the overriding rule, and then there are some specific exceptions to this default position. And this is where things can get complicated and where ethical dilemmas arise, right? If we think back to our example again, of the counselor Well, the counselor is wondering if there is an exception to confidentiality that can be implemented in order to report a client who is potentially violating a rule or regulation. At the legal level, we see that there are some instances where a client's right to privileged communication has significant limits. Generally, these legal limits are implemented at the state level. One category of instances in which we are not only allowed to break confidentiality, but in which we have an ethical and legal responsibility to break confidentiality falls under something called duty to warn. Duty to warn arises when a patient has communicated an explicit threat of imminent serious physical harm or death to a clearly identified or identifiable set of victims. So basically, if somebody has a specific plan to harm someone, and we are aware as counselors that such an explicit possibility exists, we're obligated to take steps to warn appropriate individuals in order to prevent that from occurring. Now, interesting, there's less formal guidance about what exactly that means in terms of whether you're supposed to directly contact the individuals who are potentially under threat or, on the other hand, legal authorities. My recommendation is to consult with colleagues, consult with supervisors, consult with policy experts that are available to you, perhaps as specialists within your agency. Try to identify the best person to report to. In my view, that's likely going to be a protective authority such as the police. So regarding these limits to privileged communication, there are a range of situations when most often the state curtails individual rights to privileged communication. In cases of suspected child abuse or child neglect, counselors are mandated reporters. So if we learn from either a client who is a child or from a client who accidentally or intentionally sort of confesses to harming a child, we have a legal obligation to report to the necessary and appropriate authorities. There are other instances regarding criminal behavior which we can be required to disclose information. When we're facing these types of situations, we want to avail ourselves of an attorney's services and really get appropriate legal guidance. It's impossible on the front end of all experience as a counselor to identify inclusively any and all situations in which you'd be required to break confidentiality. So when potential situations arise, it's important to consult with colleagues and also to consult an appropriate legal authority. Basically, you want to be able to identify resources in your kind of professional practice circle that can help you navigate through these types of issues. And specifically, an attorney, if we're talking about subpoenas or situations where individuals are kind of bringing pressure to bear on you that would have you make an exception to confidentiality. So regarding duty to warn, and actually mandated reporting as well, and thinking back to our advisory opinion archive example, the biggest thing is to establish informed consent at the beginning of the counseling relationship. Now we're going to complete a coming up where we get a chance to develop an informed consent document that's realistic, that could hypothetically be actually used in practice. And in an informed consent document, we want to try and lay out for our clients in comprehensible terms that there are limitations to confidentiality. To lay out parameters that give them an idea of the types of things that you may be required to breach confidentiality over. Now, I know I just said a second ago that we can't identify on the front end every instance in which we're required to breach confidentiality. And this is true, but we can provide clients widely encompassing parameters regarding events that necessitate breach of confidence. Clients should be aware that there are legal guidelines that will require you to breach confidentiality in certain situations. Another instance where we can be ethically and legally required to break confidentiality is instances where suicide is a possibility. In this category, we want to be acutely aware of warning signs like clients talking about wanting to die, looking for a way to kill themselves, talking about feelings of helplessness, feeling trapped or being in unbearable pain, maybe talking about being a burden to people. Other warning signs for suicide include increased use of drugs or alcohol, increased agitation, and significant behavioral changes. These can all be indicators of suicide. So this is a clearly difficult issue, right? We obviously want to protect people, and we want to make sure that no one gets hurt. On the other hand, we can see how it can be difficult. If we're working with someone who's been really hard to reach, maybe a really kind of guarded person, and perhaps this person is addressing some feelings of hopelessness and describing feelings that to some extent perhaps line up with suicidal behavior, but who isn't considering suicide. Well, obviously there's a risk of losing a client who feels like they've been vulnerable through sharing their feelings and then feels betrayed if we take steps to prevent a suicide that they were never planning. So I think what I'm saying is, and I don't want to recommend the wrong thing here, but I guess I'm saying I don't want to recommend that the first time a client demonstrates any of the signs in isolation that are associated with suicide, that we right away go down the path of assuming that's what the person is going to do, exactly because we want to keep them safe. And sometimes what keeps people safe is keeping them coming back to therapy and kind of contributing to their trust in the therapy situation. And if people feel betrayed, they may not come back. So I'm certainly not advising against being aware of signs of suicidal ideation. And I'm certainly not saying that I'm opposing the idea of taking steps to prevent suicide. I think what I'm saying is we do want to be cautious as we make these assessments. And we want to avoid implementing a breach of confidentiality anytime a client makes a dark comment, because losing someone that way is also dangerous. So in the current Code of Professional Ethics for Rehabilitation Counselors, confidentiality is addressed 56 times. Well, this is up from 30 times in 2002. This increase in material focused on confidentiality is definitely influenced by findings such as those in the Shaw and Lane study. So when the current code first came out in 2010, CRCC had this website that was focused on the top 10 changes to the Code of Ethics as identified by CRCC. And 6 out of the 10 out of the top 10 changes were actually included confidentiality as a for example, there was new specific guidance added regarding a professional disclosure statement. We're going to dig into this a little bit more closely next week. Informed consent is another piece of in line with the professional disclosure, and like I say, we'll talk about that next week, and then we will also have our assignment focused on developing an informed consent document. Confidentiality standards related to technology and distance counseling were also rewritten and further developed. We will be focusing on those more closely in a couple weeks. So, forensic practice. Forensic practice refers to any time that we are providing expertise as rehabilitation professionals or counseling professionals to someone other than clients, if you will. So this can be, we could be in the capacity of providing expert witnesses, maybe providing a mental health assessment on behalf of an agency. Any time that we're working for someone other than the individual who we might kind of naturally think of as the client. So the Code of Ethics, the current Code of Ethics implements more detailed standards regarding the need to clarify role expectations and the parameters of confidentiality with basically anyone who's an interested party, evaluee, colleagues, other agencies that you might be working with, or individuals who might perceive themselves as clients. So this can arise in situations where attorneys are looking for counselors to consult on a case. You're asked to address the mental health status of a client, let's say a client, an individual in custody. I think I mentioned the expert witness role. Essentially, you want to make sure that the person about whom you're consulting, so the individual, the person who you might think of as the consumer, even though in this situation they wouldn't be, you want to make sure that that person explicitly understands what the role of confidentiality is going to be, and how confidentiality in that relationship is not going to be the same as if that person were actually your client. Another area where confidentiality is addressed in the new code, and to me this is specifically interesting and actually in some ways surprising to me. The code kind of builds in a little wiggle room around working with terminally ill people, and specifically terminally ill people who may be considering hastening their own death. this could be someone who anticipates a very long and painful death um, without some kind of intervention to hasten that. The reason that I find this guidance somewhat surprising isn't because it's not important, but it's because around the time that the code was developed, we were seeing a lot of legislation come up around right to die type issues, or physician assisted suicide, sometimes it's called. Um, and my sense is that in those areas, I feel like we're likely to um, eventually see the code of ethics come down on the side of the person who wants to make the decision for their own life. It's purely prognostication on my part. For now, what the code says is that we have latitude, basically, in terms of breaking confidentiality if we think someone is going to harm themselves. Someone with a terminal illness who's going to harm themselves, we can share information with a family member or a physician. It seems to me fairly clear that this would especially be the case if we are not talking about someone who is pursuing hastening their death in a medical environment with the assistance of a physician. Um, we are not bound to the same standard of confidentiality there. And the last change that I'm going to talk about that was implemented with the 2010 Code of Ethics was the inclusion of a standard relating to cross-cultural definition of confidentiality. Um, I think the wording of this standard can be a little bit confusing. I think what's at the core of it and what's most important is that we ensure that clients understand in terms that are meaningful to them what their rights are regarding confidentiality and what the limitations of their right to privileged communication, what those limitations are. So I'm going to wrap it up there, folks. Thanks again for listening. I hope you all have a fantastic week.